Good afternoon, everyone. I thank you for joining this webinar. This is a short 30 minutes webinar. We'll talk about Opinion 483, recommended by American Bar Association, or we'll talk about in general about IS risk management. I will try to wrap it up quicker so you can enjoy some of the leftover time. Please hold on to any questions you may have till the Q&A session at the end of the webinar. So let's talk about Formal Opinion 483 issued by ABA, American Bar Association. Let me start by introducing myself. My name is Sam Vora. I co-founded ComCity in 1996 to provide IT management services to small and mid-sized businesses. Later, we broadened our portfolio by adding IT auditing and compliance services. I have been involved with IT compliance for over 15 years, have been maintaining SOX regulated IT networks since SOX was introduced in 2002. SOX or Sarbanes-Oxley is similar to the Opinion 483, but it applies to publicly traded companies. We get audited by one of the big four accounting firms for managing our listed clients' IT systems. So we are very familiar with IT compliance. So let's talk about Opinion 483. As we know, law firms are not immune to cyber attacks, and ABA wants all law firms to proactively increase their cybersecurity program. Given the seriousness of this issue and risks involved, certain guidelines have been issued by ABA. These guidelines or standards are designed to promote the protection of clients' information as well as information technology systems of the law firms. Law firms must act reasonably to stop any data breach from happening. Here are some of the rules issued by American Bar Association, as you can see on your screen. Those rules are competence, communications, confidentiality of information. So the first one is firms must act reasonably to stop any data breach from happening. And those are the best efforts, but we all know it's sort of impossible. And in the event, if a data breach takes place, they should be competent to take the steps to limit the damage. The next one is communication. Again, if a data breach happens, all the concerned parties should be informed within a reasonable amount of time. Reasonable parties could be vendors, customers, or anyone whose data has been compromised. Confidentiality of information. Any law firm or lawyers, they must take all necessary steps to ensure client information is protected against unauthorized access. Responsibility of a partner or supervisor. It is lawyer's responsibility to take all necessary steps to ensure proper measures are in place to conform to the rules of professional conduct. The last one is from this slide, responsibility regarding non-lawyer assistance. So it's not just the responsibility of the lawyers. It's if you have any third-party vendors, regardless they are lawyers or non-lawyers, or a support staff in your firm who has access to the data or confidential data, they all are responsible to keeping that data safe and confidential, but accountability stays with the senior management of the law firm. Why ABA thought about those guidelines? Because ABA has been closely monitoring the ever-growing threat posed to this sector. Recently, cyber criminals have sought to exploit vulnerabilities in order to access sensitive information. Cyber criminals then can cause significant monetary losses to law firms as well as to the clients whose private information has been stolen for illicit purposes. Why does this matter? Let me give you some statistics. The story behind this statistics is a lot of times we think, why me? I'm not a target for cyber criminals. You know, people think we are not Equifax or Sony or a big company like Target. So here is the answer to those thoughts. 70% of the cyber attacks target small businesses. Actually, target is not a correct word here. 70% of the cyber attacks happens on small businesses, and 60% of those hacked SMBs, they go out of business because they don't have resources and ways to get back to bring their business back as usual. And for bigger firms, it's a matter of reputation and hefty penalties from the authorities and, invitation to lawsuits. So coming back to the first one, small businesses, all these hackers, it's very rare that they are targeting a specific organization like it was in the case of Sony, where Sony was being targeted. Otherwise, I would say more than 99% of the times, hackers have automated tools on, surfing the web. They don't have to do any effort. They all have to run a program, and those programs are looking for open doors over the internet. And usually it's the smaller companies who don't have all the protections on their network. So whichever door they find open, they just get in. Doesn't matter how big or small that company is. So everyone is on the target. Doesn't matter how big or how small you are. So why is this opinion important? Don't think it won't happen to me because I am not a target. Again, these are not targeted attacks. There are very sophisticated automated tools which all these hackers are running to just trying to get in wherever they can. And we have all heard about ransomware. You open one bad email and that's it. All of your network is in the hands of these people, and unless you pay them the ransom, you cannot get your information system back and you cannot be operational. And here are some of the examples on your screen. All these examples are of the law firms who were victims of those kind of ransomware attacks. So the next question is, what should we do? How to oblige with ABA opinion or any other compliance or in general IS risk management? Doesn't matter, if we are dealing with SOX, as I mentioned earlier, or we work with other compliance like NYCRR or HIPAA, or it's just guidelines issued by ABA. This process starts with creating a cybersecurity program, and usually CISO, Chief Information Security Officer, has this responsibility to create and run the cybersecurity program. Cybersecurity program consists of various steps. I will talk about just few of them today. The first and the foremost is assets inventory. We need to know and identify all the assets we have. Unless we know what we have, we cannot protect. The second thing is data classification, data or IT assets classification, meaning how critical or sensitive that piece of information or asset is. Depending on the sensitivity, we talk about how to protect that asset. If it's a public information, we may not be too much worried about securing or spending a lot of resources as the information is public already. Policies and procedures. All those policies and procedures have to be documented. They cannot be just we do this as a practice. As far as authorities are concerned for any compliance or guidelines, if it's not documented, it doesn't exist. Actually, this process starts with if anyone comes, hey, what is your cybersecurity program? The first thing they want to see is what are your policies and procedures? Policies related to, how you will be securing your network, meaning what is your backup policy, which is a very basic policy, and, what is your password policy, what is your employees policy, and the procedures, again, document the procedures to implement those policies. Access control is the next in this list. Access control could be, we should not give access to the entire database to everyone in your organizations, or if you have any third-party vendors or consultants. It should be based on the role. And a small example could be marketing department in your organization needs access to marketing data. HR department has no use of marketing data, so that should be segregated. Same goes the other way around, which is more critical. Marketing department does not need access to the HR data. So why to do that? If someone in marketing department is compromised, his machine or password is compromised, the damage will stay contained only to the extent where that user have access to. The other example of the access control is how to access the data. I will explain that with an example. Whenever you need access to data, most likely you have to have some credentials. You type in your username and password to get to that data. Now there is an other second form of authentication. We call it either MFA, multi-factor authentication. So with this, you are minimizing, if you are minimizing the risk of getting that data compromised. Most of the times data, specifically email accounts, are compromised. The users fall for the phishing emails and they give away their username and password, or their email address or the password. If there is a second form of authentication, like you also receive a text message with a PIN on your phone. So even if your account has been compromised, still there is a second hurdle to pass before you can get to the data. This is becoming very popular, and it's, as of today, is a very effective way of protecting your data after your account has been compromised. Risk assessment, like data classification, we need to assess the risk tied to any piece of information or the IT assets. Again, based on the risk assessment, we decide how much resources should be spent on that specific asset. Incident management, like I mentioned earlier, doesn't matter what we do, there is no 100% foolproof guaranteed solution. If we get compromised, or I should rather say, when you get compromised, there has to be a incident management program in place, and that plan has to be documented, and it should be created now before the incident happen, meaning who will be responsible for bringing the business back as usual, and who will be responsible for informing all the parties whose information has been compromised. So those were all the risks and all the steps we need to take. So how ComCity can help you achieve your risk management or with your cybersecurity program? ComCity has the knowledge and experience to assess your IT infrastructure, to identify all the gaps to comply with ABA, and create an action plan to fill those gaps. We have the skill sets and technology to cover all parts of the compliance. In addition to subject knowledge and expertise, we also need reliable tools for disaster recovery, vulnerability scanning, awareness training, events monitoring, assets inventory, multi-factor authentication we talked about, IPS, IDS, those are the technical words I'm throwing, and this list goes on. So ComCity have, to this end, ComCity have mastered and tested all the solutions. We have partnership with various companies, and we are ready to deploy all these tools as they fit for any specific need. The other thing I want to mention is on the previous slide, we talked about CISO, Chief Information Security Officer. We can work with you in two ways. If you have a CISO and if you have a cybersecurity program in place, but you need help implementing specific areas of it, let's say you just want to implement multi-factor authentication, or you need help with vulnerability scanning or user awareness training, we can help you with those specific areas, or we can take the role of a CISO for your organization, and we can develop the entire cybersecurity program and run it. Why ComCity? We have been doing different compliance like SOX, HIPAA, NYCRR, and others for years. And we studied recently introduced Opinion 483, which is in line with what we already do. We have been helping different industries like legal, financial, health, education, and educational for their IT compliance for over 20 years. Many law firms think, why spend resources on this opinion as it's not mandatory? This is not only about checking a box that, hey, we have met all the guidelines issued by American Bar Association. This is also about protecting the data or privacy of the information you have for your clients or your partners. But it's also about protecting your own infrastructure. When you hit with a ransomware attack, all of your data is encrypted. In most cases, the data is not compromised. It's more of a denial of service attack. You don't have access to your data unless you pay some sort of ransom to these people. So this is also protecting your own interest. The other thing I will mention is, right now, this is just an opinion. Those are the guidelines. Those are not mandatory. I don't know how many of you have heard about GDPR. It's a European regulation. It's not only applies to the companies in Europe. It applies to any company around the globe if they house data which belongs to European citizens. And California is the first state in US which has a similar law which has been implemented already to protect the confidentiality and privacy of the clients across the board, doesn't matter what industry you are. And New York is the next state who is coming with the similar regulations, and those will be mandatory regulations for any company who houses data for any New York citizens. Here is the summary of everything we talked today. So ABA Opinion 483 is here. And if you are a law firm, you should comply with it. The process is to create a cybersecurity program. And why does it matter? We talked about, lot of the smaller firms, they are not able to get back to their business after the breach. How to avoid? It's creating a cybersecurity program. And ComCity is here to help in any way you want us to help you. So we will reach out to all the attendees of this webinar to schedule a complimentary compliance assessment session. This process starts with a discovery session where we interview you regarding your IT infrastructure. Depending on the size and number of locations of your infrastructure, this process takes from few days to a couple weeks. We then analyze the information gathered and come up with the assessment report. Another point I want to add is we don't necessarily need to implement the entire remediation plan immediately. What's necessary is to create a justified remediation timeline. And an example for this is if you are using a legacy application which does not run on the newer or secure platforms, but that application is, your line of business application, we need to come up with a plan how we are going to upgrade that application in the coming future and then implement that and migrate to that application. As long as we have some justified timeline, any compliance or obligation, it's fine that we are working on making the data stored in that application safe. That's all I have for today, and now I will open the Q&A session. You're still in mute mode. Please type in your questions. I will try to answer them all. If I cannot get to all the questions, I will reply later by email. So here I have the first question. Is it a mandatory compliance? Answer is no, it's not a mandatory compliance. It's opinion, or we can say guidelines or standards set up by American Bar Association to protect the privacy of the clients or the IS infrastructure of the law firm. The next question I have is how to respond reasonably if a breach happens. Do we need to inform the clients? So yes, we need to inform the clients or any party whose data has been compromised. And how to respond responsibly is it has to be in timeline. So all the parties, whose data has been compromised, they can take the necessary steps to protect the damage. An example could be reaching out to companies like, who protect your identity and, taking the precautionary steps if their credit cards are stolen so they can call the credit card company and cancel. So if a breach happens, we should not be waiting weeks. So, all the stolen information is being used or being sold. I don't see any other question So here is the end of this webinar. As I promised, I'm concluding this little early. So you have still few minutes left for yourself. I want to thank you all of you for listening, and we will reach out to you in Weasley to schedule a complimentary discovery session. Have a nice day. Thank you.